Welcome everybody. It's great to have two special guests with us this morning, Rabbi Andrew Baker and Mike Whine. We've given you their brief CVs in the invitation document, and I'm not going to waste the precious time that we have with them by recapitulating what's already there. I will say, however, that both Andy and Mike are international leaders in the fight against anti-Semitism. They were involved in the drafting of the IHRA working definition of anti-Semitism from the beginning. They were there at the creation, as it were. They have unique insights into the history, the content, the meaning of the definition, what it does mean, what it doesn't mean. We're going to hear from them this morning about all of those things and more. As far as questions are concerned, because we've got everybody on mute, what I would ask you to do is to place any questions you may have or any comments in the chat box, the chat function. I'm sure everyone knows by now where that is and how to use it. And I will relay those questions in turn to both of them as we go. But often we find that questions double up. People have the same questions or very similar questions, and we can deal with them together rather than duplicate. Just more efficient that way. So without further ado, I'd like to ask Andy to start, please, maybe giving us a little bit of the history of the IHRA working definition of anti-Semitism, how and why it came about, and just a little bit of the background to it in its original form in the EU Monitoring Commission definition and how it evolved from there. So over to you, Andy, and welcome.
Peter, thank you. Thank you. It's great to be with all of you. Yes, as you noted, before this was the IHRA definition, it was the EUMC working definition. That's the European Monitoring Center on Racism and Xenophobia. In the early 2000s, we saw a resurgence of anti-Semitism significantly in Western Europe. And we saw governments that were slow to recognize it and, of course, even slower to respond to it. With significant urging from the outside, Jewish organizations, Mike's, mine, and others, there were significant efforts to get a focus on at least identifying that problem. Various things took place in those first years. A seminal conference on anti-Semitism in Berlin, organized by the OSCE, the Organization for Security and Cooperation in Europe. It resulted in a declaration known as the Berlin Declaration. We saw the first effort of the EUMC to do its own study of the problem of anti-Semitism in the EU member states. What came out of that conference, out of that study, was a recognition that Jewish communities were really almost under siege. Significant attacks were taking place, many of them coming from parts of the Arab and Muslim communities, a hard thing for some governments to accept. And communities themselves, individual Jews, were quite alarmed. We saw a significant increase in the anti-Israel rhetoric. This was after the breakdown of the peace process, the Second Intifada, and Jewish communities themselves saw the connection. Individual Jews were being, as it were, targets, sort of surrogate targets for anger being directed at Israel. And in fact, you had government leaders that were dismissing these attacks as though somehow they were political in nature and therefore not anti-Semitic, even though the targets might have been Jewish schools, synagogues, and the like. After all of this took place, there was a recognition, and when the EUMC issued its report in 2004, that one critical need was simply a common and comprehensive definition of anti-Semitism. Notably, the EUMC itself which relied on its own monitors in the EU member states, had no common definition of anti-Semitism, and frankly, half of them had no definition at all. And so the director of the EUMC came to us, essentially to ask for our assistance in helping her and helping that center develop a definition. That took place in beginning mid-year in 2004, working through the summer and fall, and even into the following year. It involved, first and foremost, getting input from scholars on anti-Semitism, practitioners dealing with the problem, notable figures in Europe, in Israel, in the United States, and the drafting and redrafting of a definition that ultimately would need to be used in the field, as it were. So the people who would need to know and identify the problem would have this basically as a tool to do so. That meant police who were on the front line in responding to anti-Semitic incidents, governments that had an obligation, although at that time they were not yet truly stepping forward to identify, to monitor, to record anti-Semitic incidents. It went still beyond that to the justice system more generally, prosecutors and judges being able to recognize the nature of anti-Semitic hate crimes, and of course, a tool for the larger general public so they could understand the nature of anti-Semitism. And of course, one aspect of that definition, both I want to say perhaps most important at the time, but not without controversy, was understanding anti-Semitism as it related to Israel. Because clearly that's what was being understood, what was being seen. As I noted, part of that was the fact that Jews were being targeted out of an anti-Israel animus. But Israel itself in the public square was being demonized, its very legitimacy was being called into question. All of this was a form of anti-Semitism that frankly, a decade earlier, had not been on anyone's radar screen. And so working collaboratively, we developed a concise definition that we felt could be used by all of those practitioners that I mentioned in their own work. A core framework and specific pragmatic examples of how anti-Semitism may occur. Traditional ones that your audience will know well, others that were not so fully appreciated at the time in Europe. Holocaust denial as a form of anti-Semitism, and of course, what I've mentioned, anti-Semitism as it related to Israel. So that was drafted, that was negotiated with the staff of the EUMC, back and forth, and ultimately in January of 2005, we reached a consensus on the text of that definition. I should note, because it was thought important then, and it is important still now, that it had two additional statements beyond the examples themselves. It indicated that these may be examples of anti-Semitism, depending on the context. That is important. It also added that criticism of Israel, as normal criticism directed to any state, cannot be considered anti-Semitic. And so it was issued in March of 2005. It began to be used almost immediately in some governments, promoted by various organizations. As it developed, as it expanded, it ultimately gained a significant practical use. But ironically, the EUMC closed its doors. It was replaced by a different agency, the Agency for Fundamental Rights of the EU. It determined it had no mandate to offer definitions of any form of racism, intolerance, or discrimination, or anti-Semitism. So we had the ironic situation of a definition that was being promoted, even though it was in a way a kind of orphan, because we were speaking of the EUMC working definition when the EUMC was no longer operating. So it was that in 2016, in May of 2016, IHRA, the International Holocaust Remembrance Alliance, decided at its plenary in Bucharest, Romania, that essentially it would adopt the working definition as its own. And it essentially took the very same text that had been carefully drafted by us with the EUMC in Vienna all that many years earlier, with some minor editing. It was issued then as the IHRA working definition. And since then, that's how it's come to be known, and certainly how it has become more and more accepted and employed in Europe, but also around the world.
Thank you, Andy. That's a really succinct history, and I'm sure of great interest to many people. Before I cross to Mike, I just wanted to ask one question. In terms of the background that led to the need for a working definition, did the NGO forum at Durban in 2001 play any part in that? Was that part of that background? And if so, how was it perceived?
Durban was essentially a wake-up call. You know, ironically, less than a year earlier, in October of 2000, there was in Strasbourg, France, a regional planning meeting for that conference on racism. It was the host for civil society organizations, Jewish community representatives from both Europe and North America. And at that time, most of us were mostly just concerned with seeing that anti-Semitism be identified as a form of racism. If one can think back then, there was an active peace process in place. Communities were feeling more and more comfortable and assertive even in their Jewish identity. The support for Israel was wrapped up with the general support for that positive peace process. And yet it literally broke down even as we were meeting in Strasbourg that October. That's when Ariel Sharon stepped on the Temple Mount, when a second intifada began. And we didn't really realize what would follow, but it really came to its awful fruition in Durban. You had a second conference in the Middle East hosted by Iran. And so as people went to Durban, it became a place to revive the old Zionism is racism canard. Jewish organizations attending Durban were besieged, even felt physically threatened. The delegations of the US, of other countries, literally walked out because of what was happening there. So Durban certainly marked this dramatic change in the way Israel was now being demonized. But then over the following months, it played out literally in the streets of Europe as more and more Jews and Jewish communities were attacked.
Thanks, Andy. I think that's part of the essential context. And I should add, unless you want to add something further, that Durban, the Durban NGO conference was the origin of the modern BDS movement. It underwent a remake in 2005, but many people don't realize that its true origins were at that NGO forum where Jewish participants, or people who are identified as Jewish participants, were verbally and physically attacked. I'm going to cross over to Mike now because Andy's given us the history. So Mike, I'd like you and I should emphasize Mike has a legal background, a very strong legal background. I'd like Mike to just give us a bit more detail about how the IHRA working definition of anti-Semitism has been applied, and what tools are available as a guide for applying it as a standard, and a little bit more about just the why it's been so rapidly adopted in so many countries and by such a broad range of institutions. Sorry, Mike, you're on mute. We need to unmute you.
Yeah, that's better. So thank you, Peter. I'll take it on from where Andy left off. So in 2016, IHRA adopted the working definition to guide its work in combating anti-Semitism. The national delegations concluded that defining the problem was necessary if anti-Semitism was to be effectively fought, as they had defined Holocaust denial 3 years earlier. As more governments, municipal authorities, and universities adopted the working definition, the European Union's executive arm, the Commission, and IHRA commissioned research in 2020 to find out who was adopting it and how and why they were using it. They also wanted examples of good practice, which could be shared among European states and provide a checklist for using the definition across different policy areas. Adoption had to be via the head of state, parliament, government, or a combination of these. Or there could be a public endorsement via the media and/or public acceptance by the major political parties. Thus far, up until last week, 33 governments, practically all of the intergovernmental organizations and regional parliaments have adopted it. And now the European Commission has made adoption a requirement of its new strategy, the strategy for combating anti-Semitism that was launched a few weeks ago, and governments attending the recent Spanish government's Malmo conference on Holocaust commemoration are expected to adopt it. In the UK, the majority of universities now, 105 as of last Friday, have adopted it, as have the majority of municipal councils. The working definition, however, is a non-legal tool. It's not expected that governments will legislate it, although one, Romania, has done so. But the 27 EU states are now inspected annually on how they use it by the Fundamental Rights Agency, and they issued their latest report this morning, and there's a whole chapter at the back on that aspect. And ECRI, the standing commission that advises the 48 Council of Europe states on human rights matters, will use it in their 5-yearly country monitoring inspections. European law in this area is based on the transposition of the 2008 Council Framework Decision, which sets out states' obligations to penalize public incitement on racial, religious, and ethnic grounds and denial or gross trivialization of the Holocaust. And states were given 5 years to transpose the decision into domestic law, and there were sanctions for those that didn't or didn't do so effectively. The 11 examples that form part of the definition are illustrated in the handbook. And in our research, my 2 colleagues and I found that the definition is being used to train police officers, prosecutors, judges, state employers, human rights monitoring bodies to identify and track various manifestations of anti-Semitism. Excuse me. We found that it's used to categorize incidents collected by police officers, interior and justice ministries, which is now a requirement in Europe. It's been used to support decision-making processes by states, human rights monitoring organizations, the judiciary, municipal governments, and educators. It's being used to identify aspects of anti-Semitism in court hearings, prosecutor actions, police recording and investigations. And lastly, it's being used to help direct funding to civil society organizations and human rights organizations that are using it. Let me give you a couple of examples. The College of Policing, the standard-setting body for all British police forces, adopted it while it was still the EUMC working definition. few years later, the Crown Prosecution Service and the Judicial College, which is the umbrella body for judges, both recommended it. They realized that the criminal justice system needed a standard to guide their decision-making process. In Austria, judges are trained to apply it, as they are in Latvia, Estonia, and it's used both by CEPOL, the European Union Agency for Law Enforcement Training, and the Organization for Security and Cooperation in Europe, the OSCE, in their police and prosecutor training schemes. A few weeks ago, the European Commission, the executive branch of the European Union, launched this strategy, this new strategy on combating anti-Semitism and fostering Jewish life. It's important, we can come back to that later if you like. Recognizing that European states have continuously sought to destroy Jews and their communities for 2 millennia, European leaders agreed on an ambitious and comprehensive strategy to protect Jews and facilitate continuity. The EC consulted relevant stakeholders over many months to produce this strategy. Central to this is the recognition that anti-Semitism can be found in, and I quote, radical and fringe groups espousing right-wing, left-wing, or Islamist extremism. It can hide behind anti-Zionism, but it can also be found in the center of society. Since 2017, the Commission has been using the definition as a practical guidance tool and as a basis for its work to combat anti-Semitism. Again, I quote from the strategy, the IHRA definition is the benchmark for promoting a rights-based and victim-centered approach, according to the Commission. To apply the strategy and its component elements, European states are encouraged to develop national strategies on combating anti-Semitism or include its measures in their national action plans against racism and provide sufficient funding to implement them and I quote again, to adopt and use the IHRA definition. That means also encouraging local authorities, regions, cities, other institutions and organizations to do the same. They are also asked to appoint special envoys or coordinators on combating anti-Semitism and fostering Jewish life. At a wider geographic level, the Council of Europe, with its 48 member states, will now inspect states' use of the IHRA definition as a consequence of agreeing the revised General Policy Recommendation number 9 last July. This is a guidance mechanism for all European states in their exercise of human rights. My point, therefore, is that states accept that to combat an evil, you have first to define that evil and then to measure it. Measurement is slowly becoming more effective, as the annual survey from FRA published today shows, although there's been some backsliding and there's criticism, as there have been for some years past, by FRA of European states' abilities to measure effectively and to a consistent standard. Second, Europe accepts the IHRA definition, as Australia did a few weeks ago. It's not an exact science and the definition is not intended to be a law, but what it does is to give guidance to those who need to combat anti-Semitism, taking into account where it arises and how it might be used to attack Jews or undermine their situation.
Thanks, Mike. So if I could just recapitulate, and please correct me if I'm not doing this justice. The working definition is not a legal rule. It does not impose any new prohibition or purport to do so. It does not create any new legal rule of any kind. What it is a standard, first and foremost, that can be availed of in applying existing laws, existing codes of practice, and also as an educational tool. Is that a
yeah, exactly. It's a tool, it's a guide to enable those who need to monitor anti-Semitism and to provide a guideline as how to define anti-Semitism, the different ways in which it manifests itself and so on.
Okay, the next question I have is just in terms of the difference between anti-Semitic incidents on the one hand, because I would imagine the criteria for determining what is an anti-Semitic incident, such as an assault or a malicious act against a synagogue or so on. How that might be measured on the one hand, and anti-Semitic discourse on the other hand, where I would imagine the IHRA definition will have some application. Is that a false dichotomy, or is it a reasonable one in the circumstance?
No, I think that's reasonable. What you have to remember that there is this difference. An anti-Semitic act could be, but is not necessary, but could be a criminal act, because the primary act itself is a criminal act. When you add on to it the bias motivation, then that creates an anti-Semitic criminal act. Anti-Semitic speech, in most cases, need not be criminal. However, you have to look to the case history of the European Court of Human Rights. And there you find that quite a few cases have gone through domestic courts all the way through to Supreme Courts and then on to the European Court, and have been found, or rather the judgments have been upheld by the European Court. And some of them involved anti-Semitic speech. For example, the case of Dieudonné, Mbala Dieudonné, the French so-called comedian. He put on a show where he got on a well-known Holocaust denier and dressed him up, and they made fun of the shower of the Holocaust. He was convicted by the French courts, he appealed, and it went through the whole process, and then went to Strasbourg, where the European Court is, and they upheld the French court's judgment that anti-Semitic speech constituted a criminal act. But in many cases, it isn't. It's horrible, particularly if you're Jewish, but it's not necessarily a criminal act.
And I think, again, without getting too technical, for a criminal act to occur, there has to be some intent, that is anti-Semitic intent, as part of the motivation for the crime.
Yeah.
Whereas when you're talking about applying the IHRA working definition to discourse, subjective intent is not necessarily an element of it, because as with any form of racism, it is possible to be, for a form of discourse to be objectively racist, even if there is no subjective intent behind it. Again, just want to get your reaction to that.
Well, I agree. I mean, in most European jurisdictions, you have to prove intent. And that is
for the criminal act.
Yeah, for a criminal act and for speech, where that speech may be deemed to be criminal.
Yes.
So you've got to prove the intent.
Right. Whereas if you're applying the working definition just in terms of ordinary.
Well, it provides guidance. It provides guidance, but it's not in itself law. There's one country, Romania, for purely domestic reasons, that wrote it into law, but nobody else is required to do so.
But there's no requirement of subjective intent in the definition, in the working definition itself. Is that right?
Yeah.
So I think that's an important point, because there are some people, as with any form of racism, who say, well, if I don't subjectively intend to be racist, then I'm not racist. And you don't get to be a judge in your own cause. So the other thing I'll ask both you and Andy to comment on is why specifically it's called a working definition as distinct from just a definition.
Andy?
Yeah, well, you know, I want to say in a way, when it started and when it was adopted by the EUMC, it was a working, I want to say, a kind of ad hoc definition. It did not go through a process of the political board of the EUMC formally endorsing it. It was a definition that we, working together with the staff and the director of the EUMC, collectively thought needed to be put in place, with the idea that, see how it works. If it needs to be tweaked, we could do that. If people seem to feel it works as it is, we'd want to know that. But that's how it was issued, I want to say, issued relatively quickly. Again, most of the time was spent on the part of ourselves, various Jewish organizations, experts on anti-Semitism, coming up with a definition on which we could all agree, which then could be taken to the EUMC for further discussion with them. So it came to be known then as the working definition of anti-Semitism. It's become almost a kind of tradition now as the way we speak of it. Obviously, it's a definition that is being employed as written. It seemed to have worked out quite well because it has not been edited and revised. It pretty much stands today as it was when it was drafted 16 years ago.
Can I just add another 2 points? One is that it's clear it's not law. It's not written up as law, and it hasn't gone through the processes that lead to the formation of law. It's not been discussed by parliaments, let alone the European Parliament. And secondly, we already have law, which is the framework decision of 2008, which European states, EU member states, were required to transpose into their own domestic legislation. And there were sanctions levied against those states that didn't do it or didn't do it properly. So we already had the law, but the law needed some definition to focus on anti-Semitism, because it was quite clear that in some countries, the police forces didn't know what anti-Semitism was. I mean, 1939 to 45, it was clear what anti-Semitism was. But if you had "Kill Israel" daubed on the wall of a synagogue, was that anti-Semitism? Was it political comment about Israel? They needed some guidance.
It also, I think, should be pointed out that governments have formally adopted it. Parliaments have passed legislation or resolutions adopting and endorsing it. So, it's not just a piece of paper in passing. I mean, it has gained more and more formal approval.
Exactly, and in fact, the numbers that I quoted from the handbook, which two colleagues and I wrote more than a year ago now, is probably out of date by now, because the European strategy requires states to have, by the end of 2022, a national action plan to combat anti-Semitism, either a standalone action plan to combat anti-Semitism or one stuck within a national action plan against racism. And they've got until 2022 to do this. So it's not as though what we're talking about is history. It's a living document that is evolving as it is being taken up and used by governments and the law enforcement agencies.
All right. Look, I thought it was very important that we get through what the history was, what the meaning is, and how widely it's been adopted first. Now, I want to now come to some of the criticisms or the critiques that have been put forward by others. You'd no doubt be aware of a group of academics, mainly academics in Israel and possibly elsewhere, earlier this year, putting forward an alternative definition of anti-Semitism, or so it's been presented, known as the Jerusalem Declaration, which, as one of our participants, Sam Saltzman, has pointed out, seems largely to be focused on defining what anti-Semitism is not, and giving license to certain forms of discourse rather than defining what anti-Semitism is. Would either or both of you like to offer us your views about that?
I think we both would.
Yeah.
Yes. All right. Well, please, let's hear from you both about that. Thank you.
I'll jump in first. Thank you, Mike. Well, first of all, I think it is fair to characterize it as mostly focused on trying to say what anti-Semitism is not. It certainly would not work as a comprehensive definition to be used in the way the IHRA definition is used internationally, frankly. And I think we saw it emerge from a group that felt the definition would be used to chill speech, to label criticism of Israel as being anti-Semitic. And the reality is that people can make those charges. But the definition itself, the IHRA definition, says these are examples depending on the context. So you should look at the context. I don't think it's impossible that people will misuse this definition. But I think the way we have seen it become advanced as it has is people have come to recognize particularly that notion of anti-Semitism as it relates to Israel. Interestingly, AJC did a survey here in the United States only last month. It was released both on attitudes of American Jews, but the American public in general. And both the American public and certainly American Jews, by a vast majority, somewhere in the range of 85%, recognize that the statement Israel has no right to exist is anti-Semitic. If you think back when we were developing this definition, that was the very thing we felt people needed to know, people needed to understand. So I think it almost is a reflection of the definition becoming inculcated, even if people don't know its name, in more and more places, that they see that anti-Israel animus carried to an extreme really is a form of anti-Semitism. To me, what was notable about the Jerusalem Declaration was it presented itself back in, I think, in January. It created some debate, some discussion, but I don't know of any formal body that has thought it's something that can be used or has taken it on. Ironically, in the months since it was issued, I think you've had an even greater adoption and use of the IHRA definition. Mike's focused on Europe, but it's becoming more prominent in Latin America. In fact, the OAS Secretary General not only endorsed it, but he's appointed a special OAS coordinator to focus on anti-Semitism, also with a specific goal of encouraging OAS member states to employ and adopt the IHRA working definition. So again, I know that there are critics. Look, those of us who spent our lives in the Jewish world wouldn't know what life would be like without critics. So it's not a surprise that it's there, but I think it ought to be put in a certain perspective. I don't believe it has materialized in a way, certainly not in any way that its authors, that its writers had hoped it would.
Yeah.
Mike.
Let me just add to that. Look, people are free to create definitions. The Jerusalem definition is not the only one out there. There's another one that comes from Berlin. I'm sure every group of Jewish academics will each have their own definition. And in fact, when the EUMC put out the call, Andy and I and the few others that worked on it received many definitions. You know, every Jewish intellectual had his own definition of anti-Semitism, and some of them ran to pages and pages and pages. Frankly, they weren't of much help for a cop or a prosecutor. I mean, I quote this silly story. It's somewhere in my memory that somebody at the EUMC said it has to be understood by a cop on the streets of Plotzk. Essentially, it had to be written in fairly simple language. And the Jerusalem Declaration doesn't do that. And I can say with some certitude that it's of no use to policemen. I spend part of my time now, both as an inspector of the British police. I audit the British police for hate crimes. I go into the police files together with a cop, and I actually go through the crime reports and mark them out of 10 to see how they're dealing with hate crime. And I'm doing the same thing in Europe. I'm part of the OSCE Words into Action process. We're training cops to recognize and monitor anti-Semitism. The Jerusalem Declaration is of no use there, but we're getting them to accept the IHRA definition because it's got some practical value. But as Andy says, it depends on the context. You've got to look at each incident and look at the context.
Right. Okay, thank you. Look, there's another question I want to put to you, coming from Melinda Jones. The stigmatization of any kind of discourse as anti-Semitic is, particularly in Western society, a very serious allegation to make. It's not one to be made lightly. And the very fact that this working definition can be applied to particular types of discourse, and you can come to the conclusion based on the definition that this discourse is or is not anti-Semitic. If you do come to the conclusion that it is, it can have a chilling effect on debate about Jews, debate about Israel, debate about any other issue. And therefore, well, I suppose you could apply the same thing to the Jerusalem Declaration too, or to any other definition of racism. But can I just get your reaction to that? Do you think that there is a danger of the IHRA definition being misapplied in that way? Is there any evidence that that has happened to date? I note that Mike has said that the IHRA definition is the only one that has some intergovernmental endorsement, and has been, and Andy said that it's been very widely adopted in civil society. So is there some danger that, or any evidence that this can be misapplied to have a chilling effect on legitimate debate?
This, Peter, has really been the focus of some considerable debate here in the US, because the definition here had first been essentially put to use by the Department of Education, which has a special role in taking up the concern of anti-Semitism on college campuses. Now, it's constrained in how it does this. I don't want to get into the details of sort of the American Civil Rights Act and laws and so on, but it's suffice to say that it can require universities, colleges to respond if they discover a hostile environment for Jews, a pattern of discrimination. And so when the department says it will use the IHRA definition, this brings it right to the center of the debate. And the critics of the definition here had basically opposed this, arguing twofold. One was that it would be employed against critics of Israel, professors say, and they would be either forced forced out of their jobs, or forced to change how they taught, what courses they would offer, and that it would be a notable and noticeable result of putting this definition into place when it comes to the university life. This goes back several years. There's been no example of this happening. And therefore, the argument by the critics has been extended to say, well, it may not have a direct impact that's measurable or that one can see, but it will have a chilling effect. In other words, a teacher may not teach what he would otherwise do or say what he would otherwise say for fear that, or lest this definition somehow be employed against it. Now, I don't know how you can measure the chilling effect, but I think, and when we had some debate and it went back to at least one congressional hearing several years ago in Washington, you had, I think, more than enough examples of the chilling effect on Jewish and pro-Israel students on campus to do what they wanted to do because of this strong anti-Israel animus that was playing out from Israel Apartheid Week to student disruption of Hillel activities and so on and so forth. And so I recall quite vividly at this congressional hearing that when one of the critics of this definition referenced the chilling effect it might have, one of those members of Congress, Ted Deutsch from Florida, said, well, what about the chilling effect it has even on my own kids who are in college? So I really do think that that is it is a frequent criticism offered of the IHRA definition by those who want to stand against it. But I really don't think it's an argument that has merit. And I would say that particularly in the United States, where you have a very strong, almost absolute First Amendment protection of speech.
I think the situation in the UK is similar. It's not as severe, if you like, but certainly in parliamentary debates and in the evidence offered to the parliamentary inquiry into anti-Semitism, these objections were put forward that the working definition would having a chilling effect, but nobody could show that this was the case. So people were saying, oh, it will, but where was the evidence? Whereas there was plenty of evidence to the contrary, that Jewish students were finding great difficulty in holding Jewish events, in holding a Shabbaton, or in using Israeli kosher food as a consequence. So I reject that argument that the use of the definition has a chilling effect. There's no evidence. I mean, you don't see any reduction in anti-Israel speech in European universities. You know, where's the proof?
Yes, quite. Same in Australia. I mean, there's certainly no evidence of any tempering of anti-Israel discourse in university sector or any other sector. In fact, quite the contrary. We have online the president of the Australian Union of Jewish Students and a number of officers of that organisation, and we have from them a dossier of incidents where, quite the contrary, as you pointed out, it's Jewish students who are being chilled into silence or bullied into silence by lecturers, by tutors, in some cases by even non-student activists who come onto campus who want to prevent them from expressing their views, not only about Israel, but certainly about Israel, but also about other issues that are of importance to the Jewish community, including the IHRA definition. So yes, I think that's what you've said about Europe applies equally in Australia. That's certainly
Peter,
the evidence from us.
If I can just add one more
Yep.
comment. You know, I was earlier this fall in Malmo, Sweden, for this conference that the Swedish Prime Minister hosted, and it was notable that Sweden, which has adopted the IHRA definition, the Prime Minister himself saying adoption means all of its examples, clearly including those related to Israel. At the same time, Sweden has been one of the most critical countries when it comes to Israel and Israeli policy, the only EU country to formally recognize the state of Palestine. Criticism of Israel is not incompatible with understanding the value and the purpose and supporting the use of the IHRA definition.
Yeah, quite so.
I saw in the chat there was a question from a Steve Lieblich.
Steve, yes, I was just coming to that now.
Oh, all right. Well, then you ask the question in case nobody else has looked at
No,
the
I
chat.
mean, look, if you've already read it, you can answer it, but it's basically how do we best promote the use of the IHRA working definition to guide public discourse in academia and in the media.
Well,
So
go to the website of the European Commission and look at the handbook. That's exactly why we wrote it at the request of the European Commission. What's good practice? How are organizations and states and the law enforcement agencies actively using the definition, and in particular, how are they using it to guide public discourse? So we can do that, but I mean, some of our responses should have given some answers as well. But certainly the European Commission handbook gives it, and also the ECRI GPR to a lesser extent, because it's really focused on governments rather than civil society. But you've got plenty of examples. You just got to go online.
Thank you. Andy, did you want to add to that?
No, I think, look, I think what Mike said is clearly the case. And you can find, I want to say, more and more examples of the IHRA definition being put into place in a variety of settings that would probably resonate to what you might need in Australia. I mean, we may be speaking about the role of governments, but we've had local municipalities adopting it. It's becoming more and more a tool used by sports leagues, football in Europe, in the UK, other sports here in the US. I think, for those of us who want to say we're present at the creation, it's kind of a wonderful thing to see. I mean, we know at the time it was controversial because there had been no definition. And the idea of having one that was going to be intended to sort of be used, as it were, by everyone, and one that would be so comprehensive that it would fully embrace this area of anti-Semitism related to Israel, which, again, in 2004, 2005, was very controversial. But now to see how it has really gained such a foothold, really across the world. I mean, here you are putting it to use in Australia. We see its growth inside Europe, certainly here in the US and Canada, and also now in Latin America.
There's just one extra point I'd like to make, following on from your observation, Andy, about Malmo. The same could be said about the British Labour Party under Jeremy Corbyn. And they actually had the debate about the IHRA definition in 2018, didn't they, Mike? In fact, all of these arguments about, the alleged chilling effect, whether it would stigmatise legitimate criticism of Israel as anti-Semitism, whether it would supposedly weaponise the charge of anti-Semitism to manipulate political debate. All of these things were raised in the context of the UK Labour Party's conference in 2018 and were rejected. And in fact, over I suppose through gritted teeth, as it were, even Jeremy Corbyn had to acknowledge that the definition is a legitimate one, an appropriate one in all of its parts. And it was ultimately adopted by the UK Labour Party, as it has by the Australian Labour Party, including all of its definitions without amendment. Have I summarised that accurately, Mike? Or is
yes, you missed out a couple of the processes, because first they accepted it, then they rejected it, and then they accepted it again. But yeah, they just kept changing their mind. But in the end, they plumped for accepting it without amendment, and it was voted on.
Well, nobody can say that it was, snuck through, as was falsely alleged here recently with regard to the New South Wales conference. It wasn't snuck.
Absolutely not. I mean, I don't think any issue has been so discussed as either anti-Semitism or the working definition of it.
Well, here in Australia, one of the academics who alleged that it had been snuck through had actually written an article about it beforehand, which was published online, warning about, the party about to consider it in New South Wales and why it was wrong and why it shouldn't be even countenanced, and making all the false characterizations and charges against it. So, I mean, it's not exactly, hasn't exactly been a bona fide allegation. But look, guys, we're getting to the end of our time. Is there anything either of you would like to add? I think we've covered all the questions. But if there's anything either of you would like to add to what you've already said, any points that you think we haven't covered?
Well, in respect of Australia, your government has adopted it. There has been some criticism, fine, but it's up to the government now to use it. Adopting it is one thing, using it is something else. So it should be used to train policemen. It should be used to train prosecutors. It should be used for the training of judges, or at least given to judges, because they're very jealous of their judicial responsibilities. Nevertheless, they require guidance. And in fact, in the UK, rather than talk to judges, it was written into the judges' bench book which a judge takes with him to court and which gives him guidance on the application of the law, not on the law itself, but on how to apply the law. And that's where it was written up. So, it's up to the government now to take the process forward. And once the criminal justice authorities have sort of started to work on it, then universities, as I said, the majority of British universities have now adopted it. But it also fits in very well with UK's equalities legislation, which is based really quite strictly on the European Convention of Human Rights. So, you should look to how it could be used effectively in universities.
I would just add that in closing, Peter, that I think it's important to note, we've spoken about governments, spoken about different organizations, civil societies, but, and someone asked about Durban 2021. There was, of course, at the UN this fall, a 20th anniversary event marking that Durban conference. And frankly, significant UN member states boycotted it or attended it only at a very low level. I think a recognition of what you had described of what it was and how it's viewed. But at the same time, we see the UN also now in different ways promoting the definition. You have the report of the Ahmed Shahid, the special rapporteur on freedom of religion and belief on anti-Semitism. He lays out the definition in full and recommends its use. You have a special designated coordinator by the Secretary General of the UN in Miguel Moratinos, adding to his role as High Representative for the Alliance of Civilizations. He's taken this on. He was with us in Malmo. He wants to promote the use of the definitions, not only to UN member states, but inside the UN system itself. So UN staff around the world are trained to understand this. So these are all, I think, great examples of how the definition is frankly demonstrating its very real value. It almost, as it were, sells itself. But to close, I want to say the real unfortunate situation is we still need it. I think with all the positive efforts that we can identify in governments and other bodies recognizing and addressing the problem is still quite significant and still very real. So we can wonder how it might be without these efforts. Surely so much the worse, but we're still facing headwinds. We still have much to do.
And if it's alleged that that the definition, the working definition, has a chilling effect on criticism of Israel, it doesn't look to me as though the UN got the memo. Mike, anything you want to, any concluding comment you want to make before we?
You said it all. My last point really was my final point, that Australia should now start to use it in a judicious manner, but certainly the police, the prosecution service and the judiciary should be brought up to speed on it. In the British Police manual, which goes to every police station, I don't think they've got, it used to be it was given to every policeman on graduating from the police academy, but I think they ran out, and so now it's in every police station. But you've got the working definition written out in full in the chapter on dealing with anti-Semitic hate crime. And the prosecutors got a memo from senior official in the Attorney General's office saying, here is the working definition, use it. If you see it, it applies to this case. And as I said, the judges got it in the bench book, which gives guidance on how to apply the law. Australia could follow suit.
Well, unfortunately, we really have our work cut out for us on that score, because quite apart from general ignorance about anti-Semitism, I think there's broader ignorance about racism more generally. it's getting a little bit better, but it's still very widespread in our law enforcement agencies. It's not, you know, the phenomenon is not well understood. And we don't even have a uniform system in Australia for defining, categorizing and recording hate-motivated crime. I mean, you've had these systems in place in the UK and the US and Canada since the 1990s. Here in Australia, we've got different systems in different states, different definitions, different resources, different levels of police training. We don't have a uniform national system at all. And I mean, we really have an enormous amount of work to do here, and it's not even a political issue. It's not even on the political agenda. But hate-motivated crime is growing. That's the anecdotal evidence. There's more and more reports of it, and yet there's no uniform system to define it, classify it.
There should be a uniform system.
Of course there should, and we've been pressing
governments that it's necessary.
We've been pressing governments to do this for for a number of years.
You have to find allies.
But it's just
go along with you.
You know, it's the squeaky wheel syndrome, and yeah, we do have allies, but it's not seen as a priority issue, and until it does become one. And
well, that's always the case. You've got to move it up the list of priorities.
Some terrible incident to put it on the political map. Look, Andy, Mike, thank you both so much. It's been really instructive to hear from you. I've learned a lot. I do hope everybody participating has learned a lot from listening to you both. It's been a joy to get your wisdom and your insights and that great sort of corporate history that you both share. The IHRA definition was the work of many, many people, Jewish leaders like yourselves, as well as European officials and many others. And that is partly its strength. It came from many sources, and it reflects overwhelmingly the life experience of Jewish people everywhere. And I think that's why its authenticity has just shone through. People understand that. So thank you both so much for your time. I know it's an awkward hour for you, Mike, in particular, so thank you for that. And thank you, Andy, again, for making yourselves available. And thanks everyone for participating. I hope you got as much out of it as I did. I really think this was a worthwhile session. Gentlemen.
Thank you.
Thank you.
Next time.
Thanks.
Thank you guys.
Bye.
Bye now.
Bye-bye.